Justice Barrett?
Mr. Harris, I'd like to talk about the relevant analog in these anti-poaching laws. And one question that I have is along the same lines as Justice Kagan, which is when you're thinking about these anti-poaching laws, you're thinking about a problem that arose at the time. So at the time, poaching was a problem, and so legislatures enacted this regulation to address the problem. In an agrarian area, an agrarian society, that was it. Let's imagine that Hawaii, rather than just flipping this default categorically, instead is experiencing, say, a rash of gas station robberies. And doesn't want to make the argument that gas stations are sensitive places. That would be a tough one. So instead flips the presumption, like the anti-poaching laws, just with respect to gas stations. Is that okay?
Not okay, and it still runs up in the basic distinction that we're seeing, which is when the history and tradition is for the type of property open to the public, to have an implied license to go into the property, when the state is trying to load the dice, when it's trying to say you generally can't go there, it has to point to relevantly similar analogs that are doing the same for the how and why. And the anti-poaching laws, it's not just that they're about hunting, it's about that they're this specific part of land. It's almost like they're the exception to the general rule that on property open to the public, you can generally carry, on property closed to the public,
how do you know that's the relevant distinction? I mean, it could just be that, well, that is an incidental of the problem. I mean, that just happens to be where the problem of poaching arose, which was on enclosed lands, because those are the people who were trying to protect themselves from poachers. But I mean, there might have been poaching on open lands too. And then the legislature might have responded differently. I think this is this problem of just because the legislature didn't address a problem because it didn't exist at the time, why does that mean that the analog ties the legislature's hands now?
And I think the answer is that is you look to the broader articles and I think history of what was going on with the anti-poaching laws. It's not that, poaching on or hunting on lands open to the public wasn't a problem. It was actually, at the founding, it was a hugely politically salient and highly debated issue, so important it was in state constitutions, that this was a sort of elemental distinction to the founding generation that's carried on our property law, that property open to the public is not, you're not trespassing if you're hunting on that land. And property closed to the public, you want to protect the improvements, and so you are allowed to restrict it by changing the rules so that you have to affirmatively consent. And I think you know that from the laws themselves, actually. I think the laws themselves make that distinction. I point you to the New York 1763 law. The 1771 New Jersey law is of a piece with that, and the Sigmund article is sort of canvasses the history, but I think this is not just, well, it's sort of strange they were focused on this particular type of land. What do you draw from it? It is, they were extremely focused on this because it was a huge political topic.
Okay, but Ms. Harris, then that raises this question for me. In footnote 1 of your brief, you say this case does not concern property closed to the public. So the court need not address state laws that prohibit carrying a firearm into a private residence without the owner's affirmative consent. But both you and Mr. Beck are drawing this distinction in the anti-poaching laws between property that is open to the public and property that is closed to the public. So I guess I don't understand how, if you win this case and we do the history and tradition analysis and you win, how is the court supposed to distinguish that analog in the way that you're proposing we do without deciding this question you tell us we shouldn't be deciding?
Right, so I think two things are important. One is when you're deciding whether the analogs are on all fours, it's inescapable, and it runs throughout the position that there are different permissions, different common law traditions applicable to property open to the public and property closed to the public. I don't think that is a complete answer, and the reason we're saying it's just not presented is it's not the question presented. To whether property closed to the public, what the range of permissions is. For instance, if I invite someone to my house, what is the tradition with respect to that?
So maybe the state could flip the presumption in the way Hawaii has done here, but just with respect to private residences? Mr. Beck said no to that.
We're leaving that open because we're thinking of this as, again, different property traditions, and so they would have to show a relevant history and tradition. Again, I think that would be likely easier for them because the rules regarding property closed to the public have always been different than property open to the public.
Okay, last question. On your broader argument, you state the rule pretty broadly. I'm looking at page 11 of your brief. You say, a law is per se unconstitutional if it broadly prevents ordinary Americans from carrying protected firearms in public. Who is an ordinary American and why? Kind of throughout your brief, you use that formulation, but as I recall, in Heller, it says ordinary law-abiding Americans. Why not the law-abiding, and what is an ordinary American?
I don't think we're trying to suggest any difference between ourselves and Heller and our position here. I think we're frankly using it as a shorthand.
Okay, thanks.
Justice